Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
Individual defendants Brad Garlinghouse and Chris Larson have written a letter in response to the Securities and Exchange Commission's request for partial reconsideration and clarification in light of the court's DPP ruling. The plaintiff filed a long-awaited motion earlier this month asking the judge to overturn her own decision ordering the SEC to turn over drafts, notes, and emails relating to Hinman's 2018 speech, which was found not to be protected by deliberative process privilege due to the SEC's claim that the speech was merely his personal opinion. The SEC now claims that the speech constituted public guidance, a legal term. Ripple's counsel responded to the SEC's request by saying the motion was an inappropriate attempt at a do-over simply because it is dissatisfied with the court's order on its prior briefing. According to the Securities and Exchange Commission, there is no pretense here that the demanding standard for reconsideration has been met. Instead, it aims to outline a topic that has been hotly debated for over a year, but this time on the basis of a new theory that is a near-total reversal of the preceding sequence of events. Despite its prior briefing and a sworn declaration from former Director of Corporation Finance, William Hinman, in which the SEC claimed that Mr. Hinman's speech simply expressed the speaker's personal views, a position the SEC now knows cannot support its privilege claim, the SEC now claims for the first time that Mr. Hinman's speech was the culmination of and reflected a policy process within the Division of Corporation Finance. This reversal is directly contradicted by Mr. Hinman's sworn declaration. Did you know about this, by the way? Let us know what you think in the comments section below. In a similar vein, the SEC presents a brand new 5-page declaration from someone who has no first-hand knowledge of the issues attested to, and does so without seeking permission or offering an apology, in flagrant violation of the local rules. Despite its best efforts, the SEC eventually fails to show that this court's order of January 13th, 2022 was incorrect. Guys, this week I came upon a very interesting website. See the link in the description below. It's called Stable Pool, and everyone who registers on their website until October 31st will receive up to $50 in crypto. It's a new platform, but during the first week, they received more than $80 million of investments. They also have a partnership with a Japanese exchange called TaoTaoX.com. When you go to their website, you can immediately claim the free $50. After that, you go to Top Up on the left side of the screen. Then at the right, you select a currency and enter the amount you want to deposit. After that, you are free to go and earn money. Note, I'm not a financial advisor, and investing is always at your own risk. The SEC will be unable to show that the court failed to consider or credit Mr. Hinman's adduced testimony or the SEC's representation that the speech expressed Mr. Hinman's personal views because the court considered and credited both Mr. Hinman's sworn statements and the SEC's representations that the speech expressed Mr. Hinman's personal views. Furthermore, the court had previously acknowledged that SEC staff members were involved in discussions surrounding the speech, concluding that such discussions were merely ancillary to actual policy making. Additional evidence, which may or may not be included in the SEC's self-selected documents, has no bearing on the investigation's conclusion. The communications will not be attached, according to the DPP, because they did not form an essential link in a specific consultative process. Because the conversations appear to have focused solely on what should be stated in the speech, they were at most merely peripheral to actual policy formation, the report concluded. Finally, the SEC's erratic approach to litigating this matter only emphasizes the importance of the speech drafts and related communications for purposes of discovery, which defendants are in any case entitled to. Do you believe Ripple will succeed in this case? If that's the case, you'll want to give this video a thumbs up. Before we move on, check out the links in the description of this video to see more about iTrust Capital and earn a free $100. iTrust Capital offers tax-free crypto, guys. You can invest in cryptocurrency using your IRA. You can withdraw the cryptocurrency from this account tax-free after you declare your retirement. And what's better, if you sign up now, you get $100 free. There is no cost, no monthly fees, and no setup fees. Simply click my link down below in the description to open an account, then fund it for free tax-free. The only time you'll pay money is if you want to stop moving and do a little shuffle and bustle. All trades are tax-free within IRAs. Bitcoin, Ethereum, Polkadot, and Chainlink are among the tokens in which you can invest. Avalanche is being added, Stellar is on the platform, XRP will be added right after they have won the SEC lawsuit. You can also invest in gold and silver, so definitely check it out. Visit the link in the description of this video, set up the account, and claim the free $100. Mr. Jeremy Hogan, a partner at the law firm Hogan & Hogan, was moved by Ripple's response to the SEC's motion. First, to express his gratitude for the well-written brief that dismantles the several discrepancies presented by the SEC in reference to Hinman's speech, and then to express his dissatisfaction with the SEC's motion. Wow, Ripple surprised me by coming out with a bang, and this brief did not disappoint. This is without a doubt the most hard-hitting brief in the case so far. I don't think the judge will be able to help the SEC get out of this tangled web. Ripple lawyers are professional and very observant in explaining that if the court were to accept the SEC's new theory regarding the speech, then the court would be forced to accept that Hinman lied under oath, according to Deaton. The fact that the mediation will be held by Judge Sarah Netburn, who has seen all the documents in camera, could work in Ripple's favor if the case goes to mediation. She knows exactly what's in the emails, etc., and if I'm right, the SEC is the problem child here. That could make all the difference. A good mediator can sometimes perform miracles. According to his comments, his best guess is that a settlement will be reached in April or May, which will be beneficial to the XRP community. After that, whatever happens will determine how things turn out. Ripple, XRP holders, and the entire crypto community will be keeping a close eye on the proceedings in anticipation of a decision by Magistrate Judge Sarah Netburn on the SEC's petition for reconsideration. As a result, the attorney appears to be optimistic about the outcome of that decision, as well as the future verdict on the Estabrook notes, based on his tweets detailing his predictions. I believe the court will deny the SEC's motion for reconsideration, as well as the judge's decision that the 63 Hinman speech emails must be made public. As a result, I expect the Estabrook notes relevant to the meeting with Roisman to be handed over as well, John Deaton wrote in a tweet. Third parties, such as officials from Consensus and the VC Working Group, were among those most likely to have taken notes during their meetings with the Ethereum Foundation, according to Joseph Lubin's statements in January. This plethora of evidence has the potential to tip the scales in favor of the defendants in the long run. Deaton also claimed that a complete victory is within reach, and that the filing of this motion could be crucial in bringing the SEC to the negotiating table and putting an end to the XRP dispute. Deaton is one of the co-founders of the Ripple cryptocurrency exchange. Gary Gensler has been told that Ripple has a good chance of winning. This emphasizes the importance of Judge Netburn's reconsideration decision. The SEC will only come to the table, if at all, if and when it is forced to turn over the 63 Hinman speech emails and possibly other notes. A settlement could be reached as early as April or May, according to Jeremy Hogan, a partner at the Hogan & Hogan law firm in Orlando, Florida, who has a positive attitude towards Ripple's cryptocurrency community. Because she has seen all the documents in camera, and because the SEC is the problem child here, he believes Judge Sarah Netburn will have a significant impact on the next round of settlement talks. On rare occasions, a good mediator can perform miracles. In addition, a recent document shared on Twitter by attorney Jeremy Hogan suggested that Ripple's SEC case would be resolved before November 18, 2022. According to the document, the blockchain company requested that the start date of its pending class action be pushed back from August 26, 2022 to November 18, 2022. The parties agree that there are efficiencies in having certain aspects of the SEC action precede certain deadlines in this action due to the overlap of factual and legal issues between this case and the SEC action, according to excerpts from the document. Ripple also stated that rescheduling its pending class action would ease the burden on the parties and the court by narrowing the issues in dispute and speeding up the discovery process. The document makes me feel more confident in my September summary judgment prediction, attorney Hogan said in response to the recent developments. I presume Ripple believes that if it wins the SEC case in September/October, the class action will be dismissed due to collateral estoppel. Furthermore, one reason Ripple might settle the XRP lawsuit is that it is inexpensive and simple. Trials are notoriously costly, racking up astronomical legal fees and other costs. If Ripple settles, it will be able to finish this quickly and cheaply. Let's say Ripple negotiates a $10 million settlement with the SEC. In theory, that's $1.29 billion less than the maximum amount Ripple could be ordered to pay by the court. So far, the judge in the Ripple case doesn't appear to be sympathetic to the SEC. She doesn't seem likely to order Ripple to pay the full amount. A sufficiently small settlement, on the other hand, might be less expensive than taking the case all the way to trial. One advantage of a complete victory in Ripple's lawsuit is that it will not have to pay anything. That would be extremely beneficial to the company. The precedent would be beneficial to the entire crypto economy. If the judge rules that Ripple wasn't illegally registering securities, we'll have precedent that cryptocurrencies aren't securities. That would exempt the vast majority of crypto developers from paying for securities registration, financial filings, and other expenses. As a result, a Ripple victory would benefit Ethereum just as much as it would benefit Ripple. They'd be able to focus on their projects without worrying about huge legal fees. The value of their tokens might rise as a result of this. So you all know once this lawsuit is over, XRP will skyrocket. We mean, haven't you realized that everything is working in XRP's favor? First, there were lawsuit victories, then Swift was replaced by XRP, and now we may finally see the long-awaited settlement. If you want to learn more, watch our other videos where we go over all of these topics in depth. So make sure to own a minimum of 100 XRP tokens.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.